Yes, I'm on.
Yes.
Hi, Manshoor. Hi, Sumit.
Welcome.
Welcome, everyone. Our next session is on the topic of insider trading. As investigators, I find that insider trading investigations can be one of the trickier ones to crack. It can be challenging to find evidences, and many are simply ignorant of the compliance requirements under insider trading. To speak on the issue of insider trading, I'm pleased to welcome and introduce two highly regarded subject matter experts for a fireside chat, Sumit Agrawal and Manshoor Nazki. Sumit is one of the most respected legal practitioners in the financial regulatory space. He spent nearly a decade at SEBI and later founded Regstreet Law Advisors, where he now advises corporates, commodity and stock exchanges, intermediaries, as well as their promoters, key management, and investors on various issues. He also undertakes internal investigations and governance issues. Sumit has extensively handled matters relating to SEBI, stock exchanges, IRDAI, and their appellate bodies, the Securities Appellate Tribunal, and the Supreme Court of India. He has remarkable experience in the regulations around insider trading. He was in fact part of Chief Justice N.K. Sodhi committee to formulate insider trading regulations. He's also assisted in investigating the infamous IPO scam, also known as Rupalbane Panchal scam, and the Satyam scam. He's also played a key role in formulating norms for tackling frauds and unfair trade practices, registration of intermediaries, disclosures in public issues, and defended SEBI's power to seek telephone call records, amongst others. He's assisted SEBI, MCA, and Ministry of Finance, Government of India, in bringing parliamentary amendments to securities laws, in addition to handling interregulatory issues or coordinating with foreign regulators such as the US SEC, ASIC, and UK FSA. He was recently awarded by the India Business Law Journal by adding him in the list of 50 up-and-coming lawyers as future legal leaders of India. As a legal and regulatory expert, Sumit is often quoted in print, electronic, and digital media. We also have with us Manshoor Nazki. Manshoor is a partner with the Indus Law's capital markets team. He started his career working in the policy division of the securities markets regulator in India, SEBI. And he has extensive experience in the capital markets transaction, representing both underwriters and issuers. He has led transactions including domestic and international listings of equity, debt, and convertible securities, and span private placements, secondary on-market offerings, buybacks, and public offerings by issuers in a wide range of industries. He's been involved in some of the largest Indian transactions in the Indian and international capital markets. He also provides general advice on securities law matters to leading investment banks. He's written on a variety of subjects, including buybacks and aspects of capital raising, and it has been published by LiveMint, Mondac, and Prime Database. He is also quoted in leading financial newspapers such as Business Standard and Economic Times. He's also been recognized as an up-and-coming lawyer for capital markets by the Chambers and Partners Global and Asia Pacific Guides 2021. He's been recognized by Legal 500 Asia Pacific Guide 2021 for capital markets. We are extremely glad to have both of you here. Welcome to ACFE Hyderabad Annual Conference. Thank you for taking the time and joining us today. The floor is yours.
Welcome, Mr. Sumit and Mr. Manshoor. Mr. Sumit, I know through Padmanabhan. Paddy is my batchmate. We've done a lot of work together. Welcome.
Thank you. Thank you, Mr. Sharad. Thank you, Shri. At the outset, thank you, Association of Certified Fraud Examiners, Hyderabad chapter, and especially Shri, Mr. Sharad, as well as the team for organizing this conference and to provide opportunity to Manshoor and me, both of us, to speak with all of you on the subject of insider trading. Good afternoon, everyone. Insider trading as a subject seems to attract various views, perspectives across the world. It looks easy, but is complex and extremely interesting. And professionals like fraud examiners, lawyers, investment bankers, students, as well as regulators and stock exchanges, everybody is evolving with the development of this subject, which keeps changing, perhaps if not on a monthly basis, at least on a quarterly basis, depending upon the various judicial precedents which keep on evolving. Today's session format is fireside chat between Manshoor and I, where Manshoor will introduce the subject and scope of insider trading. And as we go along, perhaps we'll discuss various aspects of primary market, secondary market, enforcement, what are the various challenges and opportunities, and how fraud examiners as professionals are tasked with duty of detecting and making sure that the suspicion of fraud, including insider trading, are well tackled by them. As we go ahead towards the end, we are happy to take any questions anyone has. Manshoor, why don't we start with you?
Sure.
Some light on what is insider trading, what is prohibited, how it is prohibited, and more importantly, how regulations look at this prohibition as well as regulation. I would want you to spend some good 7-10 minutes on the subject, taking in terms of the introduction and bringing everyone on the same page, how regulators versus regulated look at it.
Sure. Sure. Thanks. And thanks, Shri Vidya and Mr. Sarath Kumar for having us. I will presume some level of familiarity with the subject for the audience, which is on this session. But I think it will still be worthwhile to just set out broadly what is insider trading, right? Basically, what are the most important aspects of it, especially when it comes to somebody who's examining a post facto situation of an act which has already happened. There are obviously ongoing compliances, right, which every listed company or even to be listed companies have to do for being compliant with insider trading laws in India. But for a fraud examiner, for example, it is always in most cases is a post facto perspective that you need. But let me just introduce before Sumit will go into how regulator sees it and how enforcement and consequences, etc., of insider trading play out. But let me just introduce the subject in a very brief manner by just highlighting the important aspects. Now, insider trading, as everybody knows, has two elements, right? It's insider and trading. So why we have insider trading regulations in this country and all over the world is to ensure there's parity of information to preserve the sanctity of the capital markets, right? So nobody wants somebody who knows something that the market doesn't know or the public doesn't know, and that person is able to either manipulate the market or he's able to just make a quick buck for himself or herself in the process. That is the underlying assumption, or that is the underlying evil or mischief that all regulators and all regulations which deal with insider trading try to plug, right? So nobody should have information basis which they're able to get an advantage when trading in the stock market. Now, obviously, regulations go deeper and into the nuances of insider trading, and not just the act of buying, selling, or trading in that sense is regulated, but even communication of information which has an impact, let's say tomorrow on the shares of a listed company, will also come into the play. So broadly, regulations in India cover two things, right? They cover how information is communicated between parties. And when I say information, I mean UPSI, right? Or MNPI, as it is called, unpublished price sensitive information, or material non-public information, meaning the same thing. I think in Indian jurisdiction, UPSI is probably more commonly used. UPSI and communication of UPSI is one important thing that the regulations regulate. And the reason why they want to regulate is also to to make sure that it is preserved, and it is not there are less instances, or at least there are processes in place which ensure that the UPSI doesn't flow out of the system into the hands of somebody who might take advantage of that UPSI, right? That's the underlying principle. So even with the regulation of UPSI and how it is handled and communicated, that the purpose still is the end result, which is in effect trading basis that UPSI. So SEBI, through their insider trading regulations, regulate how UPSI is supposed to flow. There is no complete bar, obviously, on flow of UPSI from the company or one person to the other, but it is regulated, right? There are some checks and balances that SEBI has put in place, within which the broader framework of which the UPSI can travel from places, right? One place to the other, one person to the other, one organization to the other. In most cases, UPSI originates in the list code, right? So the listed company whose shares are listed and where trading is happening, most of the information originates in that company, right? It could be things like your accounts, for example. That's very classic example of UPSI, right? Quarterly accounts, half yearly or whatever yearly accounts. Before they are made public, every person who's involved in preparation of those accounts, for example, you have auditors, you might have the finance team of the company, you might have directors who are in the know, finance directors or in charge of financial or the finances of the company. They will all know that information before it is, formalized, signed off by the board of directors and made public. So during the period from where this information becomes available to them, this information is UPSI. So most of the information that you will hear is UPSI is generated by the company itself. There are obviously some information which could be proprietary, right? Which could be self-generated. Like I might just do some research on a company and then come out with some information that only I know and nobody knows. So there's always an ongoing debate about whether proprietary information or self-generated information should be UPSI, right? When it is not originating from the company. I think that's probably a topic in itself. But suffice to say that, the pillars of insider trading in this country are UPSI for sure. And the second pillar is insiders, right? Who are insiders? Now, SEBI regulation defines who insiders are. And it is mostly people who are connected with the company who are reasonably expected to have UPSI with them because of their role in the company or the function they provide in the company, right? So your classic examples of, promoters, directors, people who are providing services, let's say lawyers, classic example, right? Merchant bankers who are involved in a transaction. They're all, in that sense, connected with the company and have access to information when it comes to UPSI, right? Information, when I say information, I mean UPSI. Obviously, if it's public information available publicly, then it is available with everyone, right? So we don't need to worry about how to contain it. So if UPSI exists, it is regulated. How you can communicate it is regulated. SEBI has very strict and as as Sumit was saying, it is an ever evolving process. You look at regulations 5 years ago, 2 years ago, 3 years ago, they will read completely different. Even the fundamentals of insider trading, whether it has to be while in possession of UPSI or as opposed to on the basis of UPSI, has undergone a change in the last few years, right? I'm probably getting ahead of myself. So just on the pillars of insider trading, I think UPSI is one, which is basically unpublished information. Mostly it's generated in the company. SEBI regulates how to transfer it, how to communicate it, how to procure it. There are ways in which it is allowed. There are ways in which it is not allowed. Now, the second pillar in that sense will be, insiders. So as I was saying, everybody who has access to UPSI becomes an insider because of their position, designation, or their role in a company, or their frequency of contact with the company even can make you an insider. And the third, most important aspect of insider trading is the trading part, right? So SEBI regulations say that if you're an insider and you're trading while in possession of UPSI, then it is insider trading, and obviously all the consequences of doing an act which is prohibitive or which is violation of the regulations follow. I think SEBI, Sumit will touch upon some of the aspects of what it means to be in possession as opposed to on the basis, which was a standard some years ago, but no longer is a standard, because there is, in SEBI's mind, there's a presumption that if you're an insider, you have access to UPSI. And if you have access to UPSI, anything you do is insider trading, right? Because you have access to that UPSI. And there is no need for SEBI to prove that your trade was actually done on the basis of that UPSI. So an insider doing a trade by itself will be insider trading. Obviously there are defenses available, and you can put up arguments when you are arguing your case with SEBI or with appellate authorities. But as the regulations are drafted, this is it's a very, I would just maybe short of saying it's a biased regulation in that sense, but it presumes that every insider who's doing a trade is doing it because he wants to cheat the system, and because he's an insider, access to certain information which that person is trying to use and make a profit.
Manshoor, before you take it further, I would want to sort of delve upon how the theme of the entire regulation on the insider trading in India works. So set in the context of Justice Odi Committee report, when the regulations right from 1992 till 2013 and 14 were reviewed, and with the various judicial precedences were taken into consideration, the new regulations came to be existing in 2015. So the way regulations were made and which exist till date, with addition of some amendments, like the recent amendments of bringing mutual fund units in the scope of securities and hence amenable to insider trading. The way regulations have been made are that the regulations primarily prescribe restriction on communication, counsel, or procuring of inside information. Then there is also a restriction in terms of communication in relation to and as well as trading in the unit of mutual funds. There is a new chapter which has been added. Then there is another part which talks about disclosures of trading when anybody who's a connected person or an insider or a designated person. While we'll get into details subsequently, but it needs to be remembered that the regulation has become complex because it uses different nomenclatures which has perhaps blurred the lines. For instance, the regulation defines connected person. Within connected person, there is a deemed to be connected person. And then within the scope of regulations, you have something called as a designated person. All these three are very, very distinct terms having different standards of proof, and the different manner of proceedings continue with the different risks and the consequences. Then at the last in the regulations for the hygiene, the listed companies or the intermediaries or even the professionals have been nudged to have something called as principles of fair disclosure, as well as the minimum standards for having a code of conduct which will regulate, monitor, as well as report trading. Now, Manshoor, looking at it today, a question which is often asked by the from the practitioners by anybody who's dealing with insider trading is that SEBI comes up with a lot of orders. And when it comes up with a lot of orders, there is perhaps a perception that insider trading can only be done in the listed companies which are quoted on the exchanges like BSE, NSE, or MSCI. I know you and Indus does a lot of work in terms of the private equity investments or in terms of bringing companies to the market, bringing IPOs or the fundraising. In that context, would you say that the insider trading is also applicable even before the company is listed? How would you look at it?
Yeah, so you're right, because as we all as lawyers struggle with reading the regulations and keeping up and trying to figure out what SEBI actually means by introducing new words in the regulations that they keep doing very often. The regulations, if you just read the text, are also applicable on to be listed companies, right? Now, to be listed in that sense in insider is still up for debate, but where lawyers and the market participants have gotten comfortable is, I think there was a discussion paper, or there was a press release which came along with the amendment, which at least was it made us reasonably comfortable to say to be listed means when you have filed the red herring prospectus. Now, red herring prospectus is a very important milestone in the listing of a company, right? So if you're getting listed as a company, in terms of the biggest milestones is probably the draft red herring prospectus, which gets filed with SEBI, and SEBI gives comments, and then you file the red herring prospectus with SEBI and ROC. The red herring prospectus becomes the marketing document on the basis of which you launch the deal, launch the IPO, people bid, and then you do, prospectus allotment and listing eventually. So SEBI insider regulations, as you rightly said, say that regulations are applicable to be listed companies, but we have always seen that to mean that it starts from when you do the RHP. Now, which basically means that when you do the RHP, when you file the RHP, the regulations will start, applying to you, which means companies which are in that mode of doing an IPO, getting listed, have to be all the more careful about the information that they have, UPSI that they have, how that is treated, right? So, like I was saying, there is no complete prohibition on sharing of UPSI, thankfully. Not yet, but so there are ways obviously in which you can ensure that you're in compliance with the regulations while also making sure that the process of the IPO or listing is not impacted. So we advise clients and we advise companies and merchant bankers who are on those IPOs on how to navigate insider trading regulations right from the time that you file the RHP and to listing. And obviously after listing, it's like any other listed company, they'll have to do whatever, right? So things like signing NDAs, for example, putting people up to notice that what we are sharing with you is UPSI. There was a very fairly recent development in insider trading where SEBI wants you to make a database, digital database of every person you have shared the UPSI with. So all of these compliances, as long as they are done, as long as you tick all the boxes and you're making sure that you're dealing with UPSI in a manner which is consistent or in line with the regulations, it is fine, and that is where lawyers also come in those transactions. Now, to answer your specific question, Sumit, there obviously, if there has been a transaction in a company which has filed an RHP but has not been listed, and the only way that can happen is off market, obviously, because the company is not yet listed, so you don't have an avenue in the stock exchange, for example, to do the trade. But if in that sense, if you have some UPSI related to an unlisted company which has filed its RHP, and basis that, shareholders are free to trade, right? They are free to transfer their shares off market in any company. There are obviously some contractual or even legal restrictions on promoters and some other major shareholders in a company, during an IPO. But a normal shareholder or an employee who's got shares through an ESOP, for example, is free to do whatever that person wants to do with the shares. So if a person, after filing RHP in a company which is looking to be listed, does a trade which turns out to be basis a UPSI, that will definitely attract all the consequences, all the actions, that enforcement actions that SEBI can take, for a normal, let's say, a listed company which is undergone this.
Right, Manshoor. Manshoor, come to think of it, we are speaking at ACFE Hyderabad chapter.
Yes.
Hyderabad is, of course, home to several well-known companies that are listed on BSE and NSE. You have Dr. Reddy's, you have ICICI Bank, HCL Technologies, Bharat Dynamics, Divi's Laboratories, you name it. You have GMR Infra, you have NMDC, PNB Housing, right? Including Satyam, which is now merged with Tech Mahindra, or you have Shriram City. So the various companies, and a question is often asked that how do you determine that the unpublished price sensitive information has come into existence? And this is one question which has always grappled the professionals, whosoever are dealing with insider trading compliance or investigation.
Right.
Have some thoughts in terms of whether it is some kind of a board meeting or some kind of a public disclosure, some contract, some NDU? At what stage will you say? Or is it completely fact-based?
Yeah, see, I think it's a great question, primarily because there's an list of illustrations in the regulation. So regulation in that sense give us a guiding set of information which could be UPSI. And like I was saying earlier, classic example is accounts. Because nothing is more UPSI than accounts for a company, right? And you see the share price movement after the financials are disclosed. So in that sense, there are obviously those few examples which SEBI illustrates, but it will always be a case-to-case analysis of what that information is and whether it satisfies the contours of the definition of UPSI, right? So UPSI by definition is information which will have an impact on the stock price of the share of the company. And to know whether information has an impact on the stock price is again a very retrospective kind of a definition, right? So you will not know whether that has an impact unless it has an impact, right? And obviously by that time it is too late to ensure all the compliances, etc., are in place. Right? That I think becomes important for investigators also, is to see whether at the time when the obligation arises on a company or a company secretary to make a disclosure of that information or to make sure that that information is treated as UPSI, whether at that time a reasonable person would think that that is UPSI, right? And not only subsequently, right? Because some information that you might think is very important for a company might turn out to have zero impact on the stock price when it is made public. and vice versa, right? So you might think there is some information which is so pedantic and which is so, so non-material in your view, but turns out once it's disclosed, the share price goes up 10%, right? So it is always a very fact-based of case-to-case basis analysis. And because the guidelines of the regulation in that sense are very subjective, right? And they are only illustrative. So it's not like SEBI says, oh, only these 10 type of information is UPS. It is an inclusive definition, not an exhaustive definition. So it'll always be a challenge for people to figure out whether that information is UPSA or not. Like I was saying, proprietary information, like a promoter's suffering from a fatal disease, right? Whether that is UPSA or not, right? We saw that happen with Apple, right? When Steve Jobs was diagnosed, and whether there were then questions about when he disclosed that, whether he should have informed public before, because definitely something happening to a promoter will have an impact. And if it is a promoter driven company, right? And which Apple was, whether something, as personal in one sense, but also something which has an impact on the share price of the company, whether that is UPS or not, right? So it will always be case to case, right? And I think, Sumit, where you can, maybe for the audience that we're addressing, it'll be probably very useful to hear from you how your perspective has changed, right? So you have obviously been part of SEBI. You have been, one of the investigators in the Satyam scam, for example, part of the Saudi committee, which came up with these regulations. And now you're on the other side, right? You're on the other side of the fence, where you're using arguments, where you're using, loopholes, for example, or, I don't want to say loopholes because it has a very negative connotation, but, you're using the regulation as it is drafted to make sure that it is applied fairly. And with all the orders that SEBI keeps passing on insider trading, everybody knows how difficult it is for SEBI, first to begin with, to establish there was insider trading. And then Supreme Court, sometimes looking at it very differently, right? In terms of intention, mens rea, or whether there was a profit which was involved in these cases. So how do you see the difference, with how SEBI looks at insider trading and proving insider trading, and when it comes to defending cases where insider trading is alleged by SEBI?
Well, this is a question on which perhaps books and books can be written, but I'll try and give an answer from the... Sorry?
And it is worthwhile to mention that Sumit has actually written a book on the subject.
Thank you, Manshoor. I think when we see what SEBI is trying to do, SEBI is, of course, trying to bring hygiene in the market where it has a system perhaps one of the best in the world. And I can say this because if you see in India, we are so used to looking towards the West and especially the American system. And the live example is that very recently, Elon Musk had tweeted that I am going to take the company private. And he had tweeted this without making a disclosure on the stock exchange. Now, the US SEC, which is considered to be one of the most developed securities market in the world, had to come out with a specific guidelines subsequently to say that till the time information is allowed, disseminated, and published on the platform of stock exchange like NASDAQ or NYSE, even if it is 20 seconds before on social media platforms like Twitter and Instagram, that will be considered to be passing on information, which is inside information, and you will be charged with insider trading under 16B of US SEC. Now, in that context, in India, the SEBI, the regulator's position has always been that whatever your argument has been, we are rightly or wrongly, we are going to discard that argument. If Securities Appellate Tribunal has to have a different view, that's a different way of looking at it. We are here to police the market, having our heart at the right place. And till the time information is published on the platform of stock exchange, any blog, it will not be considered as published. And let me narrate with a live example so that audience can perhaps more relate to it. In fact, it was a case somewhere in 2011 and 12 when we at SEBI were investigating a company which was a listed NBFC in Hyderabad. And it had received some kind of a cancellation of license order from Reserve Bank of India. On Friday, it was communicated to that company. And on Monday, before actually this could be officially given in the form of an order, on Saturday, in a Telugu newspaper, this information was published. And on Monday morning at the opening hour, promoters offloaded share. In the argument, question became, a newspaper, is it not a public platform? Whether there is any data where a stock exchange is referred to and read by investors versus a newspaper. Within newspapers, would you consider a particular following media channel or a publication to be a newspaper, but not someone who's having a lesser number of followers? Therefore, the law has to look at the precedence, law has to look at the concept. And therefore, today, more specifically in 2015 regulations, it has been said that it is primarily the stock exchange and anything else will only and only be considered as a secondary way. But in most circumstances, it will only and only be the platform of the stock exchange. Now, more often than not, the question is asked that SEBI in a broad brush is going to paint everyone, whosoever may be, the communicator, information courier, or a trader, all three put together in the same bucket and going to pass the most so-called draconian directions. Therefore, the question becomes, how do you balance it? And how perhaps a fraud examiner can help in terms of detecting an insider trading. Now, the threshold, as somebody has put in the question in the chat box, that what are the recent cases? Supreme Court recently, in the context of insider trading, and sat in one of the very recent judgment. And these are the three judgments one must actually analyze in detail. One is Abhijit Rajan, which was the Gammon Infra promoter and MD. Another is SRSR, again the Satyam connected entities, the ex-promoter connected entities. And the third is the Balram Garg. These three judgments put together have today put in the onus back on SEBI, even though the regulation said that the onus to disprove will be on the person who's been accused of insider trading, giving a wide amount of discretion to put in a charge of communication as well as trading, whether in possession or whether on the basis of information. Now, this has brought a lot of shakeup in the regulatory system, where finding a direct evidence is obviously difficult. And today, SEBI and we as India is looking at a more and more dynamic ways where information is being circulated. In SEBI's experience, there were a lot of WhatsApp chatter groups. There were lots of Twitter, Instagram, Telegram channels. There is a recent case in terms of YouTube, where the information is being spread. And information is being spread, and there is no way, because SEBI does not have power to tap telephone records. And collection of this information becomes far more difficult, and proving the connection with the promoter or the source of information becomes further difficult. So therefore, the entire cases of insider trading falls back on whether there is an existence of unpublished price sensitive information. What will you consider as information per se? Then if something is an information, which is a relevant information, is it falling in the definition of unpublished price sensitive information? What is publication? When will you consider it as a publication? How am I connected with that information? And these judgments, in fact, have put in an onus on SEBI to somewhat indicate that what is the motive of a person who is either communicating or trading to undertake that kind of an act. I think the perspective of SEBI as well as the regulated are with crossover with each other. However, in most of these cases, it is the time and the circumstances which weigh in the favor of either exoneration or getting a penalty. In terms of consequences, like your criminal law, where one of the most heinous crimes, which are murder and rape, insider trading in the securities market in civil offenses is no lesser than that. It is perhaps the only offense for which you have 10 lakh rupees as the minimum penalty, 25 crore rupees of the penalty, or 3 times of the profit, whichever is higher. We have seen in India cases where SEBI has imposed even more than 1,000 crore of disgorgement and perhaps more than 100 crore of penalty. In fact, there are cases where SEBI has even gone ahead and filed criminal prosecution for 10 years imprisonment again. So there is a new body of law in terms of disgorgement that is also developing. To put it a different perspective, to say that most of the cases SEBI is perhaps not being successful, perhaps the data doesn't say so. These are some of those cases which are headline worthy. They are only published in newspapers, but SEBI's success in terms of insider trading cases, in terms of data, is phenomenal.
So if I could just ask, see, it's all very interesting, and it's all very, in the sense that everyone will get is that, you won't know unless it happens, right? And with all these terms defined in regulations very loosely, very inclusively, in terms of guidance that comes from SEBI orders, always, depends on what SAT or Supreme Court eventually says. But, for our audience, maybe, for an examiner who's looking at, or, a company or a situation where there might have been insider trading, what can an examiner look for, right? And are there any red flags that should catch attention of somebody who's examining a company or doing, let's say, an audit or forensic or whatever for a company, specifically for insider trading?
Very interesting question, Manshoor. See, let me first start with whether SEBI per se by law can appoint a fraud examiner to detect insider trading. So, and under SEBI Act, there is a section 11C which provides power to investigate to SEBI. Under this parliamentary mandate, SEBI has the power to direct a listed company, and it can appoint anyone, including a fraud examiner or a forensic auditor, to investigate. Now, the word any person has been interpreted by courts to include even a person who's not even a SEBI officer to investigate the insider trading. Now, there have been cases where SEBI has appointed chartered accountancy firm. SEBI has in fact even appointed certain fraud examiners. SEBI has also appointed lawyers and the company secretaries also. Now, the question really becomes is, one is SEBI, which may perhaps not in many numbers in terms of volumes would have done it. Listed companies or the intermediaries like investment bankers, stock brokers, stock exchanges, they obviously take the help of professionals like fraud examiners. Under the insider trading regulations itself, there is no bar on a listed company to appoint a fraud examiner. And some of the well-governed listed companies, their compliance departments do so. So therefore, appointment of a fraud examiner by a listed company is not uncommon in India. It is, of course, developing. In US, in terms of numbers, it is far more. But in India, especially the kind of digital evidence India is seeing, the kind of involvement of forensic tools is coming, the involvement of forensic auditors as well as fraud examiners is only going to grow. Now, the second question which you asked me was that in terms of fraud examiners, what are the things which they can look at to identify what is an insider trade? See, in fact, this question has some amount of overlap of SEBI's way of looking at it, because you have to put yourself in the shoes of SEBI, that how SEBI will pick up its case. So what happens is, any trade in the stock market has to have either an impact on price or on volume. So unless there is some correlation with the price or the volume, no case of insider trading would be able to be made out. Therefore, first and foremost thing which any fraud examiner could perhaps look into will be abnormal trading activity. For example, there is a sudden increase in the trading volume, or the execution of large trades that has happened just before the significant announcement. If this unusual stock price movement, if it cannot be explained by publicly available information, you have a red flag. Similarly, if a company has disclosed unexpected revenue growth, that is another red flag. a fraud examiner can look into. Third, which in the recent cases, SEBI has seen, as can be seen from their public orders, sudden departure of their key executives. If the auditor has resigned, it's a perfect red flag for SEBI to pick up a case of insider trading as well as securities fraud. Similarly, other red flags are there where you have either a history of suspicious trading activity, you have certain, either the brokers of those companies or some key employees of those companies, they suddenly get unexplained wealth or lifestyle changes. Like in India, in the case of a specific mutual fund front-running case, which is the headlines for last 6 months, there was a particular dealer and a mutual fund related person who was going in the street in a Ferrari, and that caught the attention of the regulator as well as the stock exchange. Therefore, these are some of the indicators where one could say that here is a red flag and we need to look at.
Right, but it seems like SEBI in most cases is working backwards, right? In a way, right? So will they will see a unusual trading pattern, or they'll see a spike in the share price, and then they will start working backwards to see whether it is supported by information which was public, whether anybody else made a profit just before that information was released. And I think it becomes all the more difficult for investigators or even the companies to ensure compliances, that they have to prejudge how SEBI might look at it, right? And to know the mind of SEBI in that sense, is a very difficult task, right? Because even the attitude of SEBI keeps changing. We've seen with new management, with new top person coming in, SEBI starts reacting differently. We have experience in, at least in the IPO space, we have seen, SEBI come up with questions that they have never asked before. The focus they have, for example, on, things like KPIs, which again could be UPSI,
Right.
But how much they are looking at it, how much they're looking at pricing, and how you price an IPO and what happens to an IPO after you price. So all of these things, I think, it's very tough to prejudge. It's easy for SEBI to open a case and then start going backwards, but for somebody to ensure compliance or to see whether there has been a red flag or not, I think will always remain difficult.
I wouldn't disagree. I wouldn't disagree on that aspect. In fact, as with any other institution, and both of us having worked at SEBI, we obviously can say for surety that with the management change, and in fact, the manner in which a particular regime of a particular time looks at the kind of enforcement. For example, right now, if there is a focus on mutual funds, then perhaps the units of mutual funds have also been included. While few years before, it was specifically said that the units of mutual funds will not be securities and will not be included in insider trading. But just to put it shortly, there are data analytics tools, there are social media monitoring tools, then you have trading surveillance tools, then you have market intelligence platforms, and you have forensic accounting tools like ACL or IDEA. These are some of the technology-driven tools that can be utilized today. And that's the way when SEBI's own data warehousing business intelligence system or market surveillance system can look into, we as market participants have to also evolve if we really want to counter the charge what SEBI is perhaps bringing.
Sure. Yeah, it's always challenging to take a session just before lunch, but and maybe we're running short of time. But Shri, do you think there's time to go through the questions maybe quickly and try to answer those?
I think, yeah, maybe we can take 2 or 3 questions at least, because we do have a number of questions.
Yeah.
Funny asks if you can touch upon any recent trends in wrongdoing that you have seen in the area of insider trading. I think some of them you have covered. For example, you talked about the mutual funds one. You talked about even disclosures with Elon Musk. So I think we might fall short of time to cover. But one more that we have from Siddhant Mishra is, what is the rationale of including a pledge of securities while in possession of UPSI within the ambit of securities?
Right. So I think the linkage with the takeover code of insider trading regulations is one part. And India, in terms of financing, even in the context of listed companies, it still has a lot of data where promoter and promoter related entities have put in their shares for pledge to raise finances. Now that invocation of pledge and the information in possession of promoters definitely is something which needs to be regulated. And from that context, the dealing in securities was widened enough to include pledge of securities.
Yeah, and just to add that, what is happening in pledge of securities, right? You're still unlocking the value of the underlying shares, right? So you might not be selling it and getting the money, but you're still placing a value on those shares when you pledge, right? So if I pledge a shares to an NBFC or to some other lender who's giving me money, there is a corresponding value which is attached. So I am, in that sense, unlocking the value of the shares basis a UPSI, which is the same as selling, right? In SEBI's mandate list, because you're still getting the benefit of the value of those underlying shares, and you might be in possession of UPSI value doing that. So trading in that sense for them includes pledging. Which it should. I think there is no denying the fact that you're still unlocking a value attached to those shares.
And to absolutely, I agree. Both of you covered so well. My compliments to you. I have investigated personally many cases. Sumit knows, of course, from forensic side and from IB we are doing. In one of the classic cases before CBI we are doing right now is pledge is done. Pledged amount is used as a margin money in the availing the loan and not informed to bourses or to the bank, and he confirmed to bank that he is holding the total shares.
Absolutely.
Later they sold, the entity who lent money has sold. All hell broke loose. So the moment you are pledging, you are losing control on that. You are getting consideration for that. May not be market consideration, but nevertheless loan with entitling the other party to sell whenever necessary. Absolutely. But both of you, my compliments to you. You covered extremely well. Someday I'll share some thought process with you.
Most welcome, sir.
Having a little more gray hair than this thing having seen.
Absolutely.
A policeman.
To hear from you. Right. If there are any further questions, perhaps the audience could write to ACFE and we'll be happy.
That's so nice of you.
Right. Thank you. Thank you again on behalf of Manshoor and I for this opportunity, and thank you for patiently listening, all the audience. Thank you very much.
Thank you so much, Sumit and Manshoor. This was really insightful.
Absolutely.
And learned a lot. And I am a designated person with Infosys, but there are still a lot of concepts that are new to me. But and like you said, it's like Manshoor said, it's subjective. A lot of the things like UPSI, what UPSI is subjective. It's not exhaustive, even the way it's defined right now. So this was definitely helpful. So thank you very much for your time, and thank you for joining us on a Sunday.